You're charged with two cases. You're charged with evading arrest and resisting arrest. You're facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 22nd, 2025, at around 7 p.m., officers were dispatched to 1855 Work Road in Houston, Harris County, Texas, in regards to a criminal mischief in progress. Upon arrival, the officers observed the defendant at a location matching the description on the call slip. The officer gave verbal commands for the defendant to lay on the ground and put his hands behind his back. The defendant ignored commands and ran away from the officers. A foot pursuit was initiated, and the officers continued to yell verbal commands for the defendant to stop running. The officers were able to detain the defendant approximately 100 meters away. The defendant then actively resisted, and the officers had to dry stun him. The defendant was using both hands to push off officers in order to avoid detainment. The defendant grabbed the officer's ballistic vest and attempted to push the other officer. The defendant attempted to push officers multiple times, and the defendant struggled on the ground for approximately 3 minutes before he was detained.
What was he doing wrong? All you said, he matched a call slip. So
yes, for a criminal mischief in progress, Your Honor.
That's completely conclusory. What is the alleged mischief? What did he do wrong? Who did he do wrong to?
And I don't have that information.
Then none of that? I mean, who's writing the reports? Mickey Mouse? You know? I mean, really?
This is a pivotal moment in the courtroom. The judge is essentially pointing out that no one has clearly articulated what crime actually occurred. A call slip matching an incident isn't probable cause on its own. There's no identified victim, no documented damage, and no specific criminal act described. Without those details, the case falls apart. This is exactly why precision in police reports matters. Vague or incomplete documentation can determine whether a case moves forward or collapses entirely. The question is unavoidable. Should officers be held to a higher standard of documentation before an arrest is ever made?
I haven't heard anything. I'm going to find no probable cause. Mr. Gonzalez, be careful, man.
Okay.
When you get into a pissing match with people who have the power of arrest, who's going to win?
I'm going to be more careful. I promise it's not going to happen anymore. I promise. I got my family. I want to,
Okay.
Thank you.
Got it.
God bless you.
Dude. All right. Good morning, Mr. Walker. So, you were charged with failure to identify oneself. That's why you're charged here with us, failure to ID, right? You're facing up to 6 months in jail and or a $2,000 fine. The reason that we're taking you into custody now is because you have 2 felony warrants for, it looks like you were on probation for a felony theft, and they filed, I guess, a motion to revoke because of that warrants issued. So that's why we have you in custody now. I can't let you go because then I would get in trouble. We're going to do probable cause in our case. You have the right to remain silent. Anything you say can or will be used against you. Well, I don't want to talk about the case. You've got a lawyer. You need to talk to him, let him talk to me, because I don't want you to say something that hurts you anymore.
Yeah,
so let's just do probable cause, because I don't know why. I don't even know why we're here.
Yeah, my son, I'm gonna say the Bible, he can machine everything. There's no way to put on GPS. Like,
Well, hold on. Let's do probable cause first, because
okay. GPS.
It's not up to him. We're just talking about these things.
I can't. There's nothing I can do on the felony case, man. I'm just a lowly misdemeanor.
In his defense, Judge, the felony motion is based on technicals, and in this new case, this failure to ID.
Really?
Yeah, I don't see anything.
Well, let's do it real quick, and then we can talk, and I can give you more info.
On March 21st, 2025, officers were dispatched to a family disturbance call for service at 2525 Holsworth Road in Spring, Harris County, Texas, which is an apartment complex. The officer began by identifying the defendant, who could not provide a valid driver's license. The defendant verbally identified himself as Adam Mitchell with a date of birth of December 23rd, 1987. The reportee then gave the officers his correct name, and the defendant then admitted to providing false information due to advising about a traffic warrant that he believed he had. The defendant then gave his correct name. The officers discovered an active warrant for the defendant out of Cook County, though there was no extradition.
So there was a warrant out of Cook County.
There was, but there was no extradition.
Cook County,
for that warrant.
Illinois?
Yeah, sure. I looked at the NCIC. All I saw in there that it could possibly be was some sort of like traffic offense.
Okay.
That's all the training he's talking about. Don't say.
Not right. So he gives the name of Adam.
Mitchell. And Judge, this isn't filed as a fugitive, just a straight failure ID.
Right. Well, because he wasn't. Well, maybe he was. I don't know. Regardless, so Mr. Walker, I'm going to find that there's sufficient probable cause. Well, hold on. I'm going to find that there's sufficient probable cause to go forward in this failure to ID case. It looks
Just
like,
call the police.
I don't want to call the police. They never asked me my name.
I don't,
Like, I'm the person who called the police.
I thought it was a stop.
No, they
No.
were dispatched to a family disturbance at an apartment complex. The officer arrives, proceeds to try to identify both individuals, began by identifying the defendant who could not provide a valid driver's license. The defendant then identified himself verbally as Adam Mitchell with
Here's where the situation becomes legally complicated. Even if you're the one who calls the police, officers are still allowed to identify and question everyone at the scene as part of their investigation. The real mistake here wasn't speaking to police. It was providing false information, even if only for a moment. That alone can be enough to trigger a failure to identify charge. A lot of people don't realize this. Calling the police doesn't automatically protect you from being questioned or required to identify yourself.
1987.
I mean, I get that you call the police, but nevertheless, I mean,
Then he told him the right info.
but you still gave the wrong info, and then they looked them up, and then they get, So, I mean, there's enough probable cause to go forward.
Why would that didn't happen, but why did, like, if I call the police, why are they asking for my ID in the first place? They don't have the right to do that, sir.
They're going there for a disturbance.
Yeah,
They
because
have to, look, I can't get into all that stuff now. But they're going to investigate something that happened. There's a disturbance. They go there. Normally what officers do is they have to look at everybody who's there to determine, hey, who is this? What's going on here? Does this person have any kind of issues? And so, regardless, the good news is that it looks like on your motion to revoke, the only thing is fees that I see in this case. Okay. I can't let you go at this time because this is a felony warrant. You're set at no bond now, but you'll get to felony court on Monday. And at that point, I mean, I'm sure that they'll do something. I'm not going to,
That's crazy, man. Like, I called the police.
I'm not going
A couple fighting, and I just called the police. That's all I did, sir. I seen two couples fighting, and I called the police because there was a guy hitting a woman.
I can't give you legal advice.
She's writing everything down too that you're saying. Maybe later
Just
down the
don't
road,
say
you might
anything at
want to
this
say
point.
something
You
different.
can talk to Mr. Pons. I'm not putting any conditions on your bond. Just be careful, Mr. Walker. Okay, thanks.
What was our bond in this one? It's PR bond, right?
Yeah, he's got a PR.
No, I bought that for $1,000.
So you're.
That's
Was
right.
it
Judge,
Thanks.
6,000.
Excuse me, Your Honor, I'm approaching on Neil White.
Is he?
And Judge, he's been carried like since Monday, the 24th. That's when he appeared on your docket initially for a new charge for the bond violation report, which is filed, and also a motion to revoke and raise. But he was still incarcerated on Monday, Judge, Monday morning.
He's
He
right
got-
here now, right?
He's here now.
Okay.
But
Come up, Mr. White.
Mr. White.
We're on bond for an assault of a family member.
Yes, sir.
Since 2023.
Yes, sir.
In 2025, in February, you pick up a terroristic threat.
Yes, sir.
And now you've picked up another assault of a family member and a violation for protective orders. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 16th, 2025, in Harris County, Texas, officer was dispatched to an apartment for a family assault.
Officer met with the complaining witness. The complaining witness had visible injuries on her face, including bruising on her eye and swelling on her head. The complaining witness went over to the defendant's house. Defendant grabbed the complaining witness by the arms and threw her into a table and chairs. Defendant began to punch the complaining witness multiple times in the stomach and slap her in the face. Complaining witness attempted to leave, but the defendant followed her through the apartment complex. The defendant currently has a protective order for terrorist threat, which bars contact between the complainant and the defendant.
Is that the violation of the protective order?
Yeah, it's a felony, VPO.
Your Honor, may I be heard? Your Honor, the complaining witness shows up at my client's apartment. He lives there by himself. She shows up like at 5 a.m. in the morning. My client did not assault her in any way. Actually, the complaining witness broke his phone, and my client left the apartment so he wouldn't have to deal with her because she wouldn't go away. But at no time, Your Honor, did he assault her. I did get to check out the videos, Your Honor, where the officers are interviewing the complaining witness. She alleges that he punched her in the abdomen. She is in absolutely no distress, Your Honor, when she's talking to the responding deputies. If he had punched her in the abdomen, Your Honor, I can really say that she probably would be doubled over and would want to go to the hospital. The EMS did check her out, it appears, but she refused transport to the hospital. I couldn't tell from the body worn cam video, Judge. It wasn't close up enough, but I couldn't tell. I couldn't see any bruises and it's like I said, she was not in distress whatsoever. She is the one who really went to his apartment. He did not go, he did not violate the protective order. And
The violation of protective order is a felony offense anyways, so.
yes, Judge. Yes, Judge. I understand. I understand.
So I just
And-
have, an assault, a terroristic threat, and now another assault.
Right.
So which assault is he alleging that's
Right,
the,
Judge.
right?
Yes, Judge. And she's filed or the state has filed a terroristic threat on her behalf, a charge on her behalf. If she was so terrified of him, Judge, why is she popping up at his
I don't know
apartment?
that that's actually true. Who's saying, he's just telling that to you? I mean, how do we know that's really true?
Well, she's there, Judge. Those are the apartments that are shown on the body worn cam video. It's his residence.
Is she actually on video at his apartment? Have you seen
Outside
it?
of the apartment, they're outside on FM 1960. That is not her residence. The protective order has got a totally different address where he is prohibited from
Tell me, Sebastian.
going.
Okay, well, the VPO is not based on an address restriction, it's based on the assault of a protected person. And as far as the representations that defense has made today, we have no way of verifying any of that to be true. I disagree with the assertion that she shows no visible injuries. Her face does appear to be swollen with some red markings. Number three, the allegation that she's over at the house don't disqualify her as being a protected individual, and VPO is for an assault, not for a residency restriction. And at the end of the day, all those are fact issues. And what we're left with right now is the fact that in 2023, with a separate victim, he has an AFM, bond forfeits, then we have a terroristic threat with someone else, and now he picks up a separate AFM. And we can talk about how she's back all the time, but I think that ignores, first of all, the realities of domestic violence situations. And second of all, this isn't just one person that he's having multiple problems with. These are two separate people. So the state is going to stand on its motion to revoke and raise bail and is going to ask for $20,000 on all three cases.
Your Honor, may I respond? The complaining witness has not, has recanted to these March 16th, to the current charges, to the newer charges.
Which alleged victim is recanting, the first or the second?
The terroristic threat complaining witness, Your Honor. And the other assault family member case, Judge, the complaining witness is currently incarcerated. But
So which one's in jail?
so
The oldest one was in jail.
When?
And
Or,
I'm not sure, actually. I had a colleague who spoke to her. I forgot exactly what she's in for. She is in jail. As far as her recanting, I mean, that's,
is she in jail for something against him?
no, I don't think so.
And also, Judge, the complaining witness, the one that the protective order is on behalf of, she has not given a rip on the terroristic threat case, Judge. So something's not right. She doesn't want to.
Problem is
Tell the truth.
he keeps picking up cases. Eh, Stuff keeps happening to him. It's just, I mean, I fall down and I pick up a new case.
Yes, Judge, and I did want.
Are we supposed to just let him go because he's picked up now a felony? You
I
know?
just wanted to relate to you, Your Honor, that my client does not have funds. He paid he paid to get out with his income tax return, Your Honor. He paid to get out on these two new charges. He paid to get his car because he was not arrested at the scene, but he was arrested thereafter while he was driving. They impounded his car. He paid to get his car out. And he paid because to get a new phone or get his phone repaired because complaining witness broke his phone on the date of the alleged incident. And I'm asking the court to leave his bond as is, or in the alternative, Judge, maybe he can borrow some. He's got $250 left from the income tax return. And if you could leave it, or $5,000, he could possibly do that, but not 20.
This is the judge drawing a clear line in the sand. Bond isn't meant to be punishment. It's about ensuring public safety and holding someone accountable while a case is pending. When repeated cases, multiple victims, and prior violations keep piling up, the court starts to see a pattern that warnings alone haven't changed. At this stage, the message is simple. Leniency didn't work, so real consequences are next. The real debate is whether revoking bond is justified now, or whether the system failed earlier by not intervening more effectively.
For an entire week, Your Honor, when he was arrested for this offense, for these new offenses.
Pick up new cases. That's what happens. I have not asked you to do anything but be safe in my community. You're now working your fourth case. No, I don't want you to say anything. The only thing is that you continue to pick up new cases, and I can't just let you keep doing that without some kind of consequence. No, there has to be consequence to behavior, and the bill comes due. You can't continue to pick up new cases and expect good results. So I'm now going to revoke your bond. It goes with you. I can't. I have to show you that we mean business. Otherwise, we have no teeth. You know, what we say, it means nothing. I'm going to tell you now that I'm entering an order for protection in all these cases. And if you violate this, I can have a hearing to hold you at zero bond, and I will do it in a heartbeat to protect my city at all cost. If this person comes to you, you don't open the door. If they call you, you don't open the door. Or I'm sorry, you don't answer the phone. If they email you, you don't reply. But at some point, we have to say when. Now's that time. It goes with you.
Yes, Your Honor. Well, my bond.
I'm not going to set it that high. I think that high is obtuse, and that's just, mean-spirited to go that high. But
Judge, this is 2 years worth of history here. Two different people.
that's why they set the felony bond at 30,000. But I mean,
You gave the first victim 10 stitches in the head.
10 stitches in the head.
I read that, Judge.
Tell me about the second one. What happened with the second one?
The second one is this one, and then you want to
All right. How bad are we talking injuries on the second?
Judge, it's swelling and then bruising in the head.
All right, so I'm going to do 10,002 on the first one, 5,000. So 10,003 on the first assault, 5,003 on the terroristic threat, and then I'll leave the second one as is. The new one as is.
Thank you, Judge.
No, then it has no. I need a new one on. Do we need to file a new one?
For the original.
Okay, can you, Sebastian, file a new order for protection on the old case so we can have him sign it? On the
Yes, do you want it
2023?
on the two victims or just on the?
No, on both, on both, yeah. Mr. Johnson, you were charged, you were charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
And judges, you know the details of this case are.
Quiet.
Just.
Just read it.
Officer reviewed a police report from February 4th, 2025, after the officer spoke with the complainant. The complainant stated the defendant, her ex-boyfriend, called the complainant and stated that he was going to kill her and then showed up at her job. The defendant was approached by security and fled the scene prior to contacting the complainant. On February 24th, 2025, the fine officer called the complainant. The complainant stated that on February 7th, 2025, she told the defendant via phone call to stop harassing her, and the defendant told her he did not give a fuck. On February 12th, 2025, the complainant received an email that stated, "Skip pussy bitch, I just love you." The defendant also sent a 20-second pornography video. The video showed a female laying on her stomach, nude, and the video zoomed in on the female's vagina, with fingers being used to spread the female's buttocks to expose the inside of her vagina. The complainant recognized the hand and the fingers in the video to belong to the defendant and recognized the room. The complainant stated the defendant had previously emailed her on March 16th, 2024 from the same email, sending a picture of himself at work. On February 18th, 2025, the defendant emailed the complainant 6 times. On February 23rd, 2025, the defendant emailed the complainant 9 times. On February 24th, 2025, the defendant emailed the complainant once. The complainant changed her phone number on February 22nd, 2025, because she kept getting phone calls from unknown numbers, and when she would answer, the call would hang up. The officer texted a photo of the defendant from his Texas driver's license, and the complainant identified the defendant.
Pornography video that was sent.
We don't know the ID of the female in the video.
So, Your Honor, I think it would probably take some more investigating to figure out the identity of that female. Obviously, we can't speak independent about it. I don't know if it's like recognized her. But that is.
She would say whether she recognized it was her. I would imagine that there's a whole host.
That's a felony.
Yeah,
If it's.
we haven't spoken to her directly yet, Your Honor.
It's just because it's been in black flash.
Mr. Johnson, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to order you not to have any contact with the complaining witness. I'm going to put a GPS monitor on you so I know where you are at all times. If I find that you go anywhere near this person, if I find that you try to have any communication with this person through any means, I don't care what it is, if it's Snapchat, if it's Facebook, social media, smoke signals, whatever it is, I will put you in jail. I'm going to do everything in my power to protect my community at all costs. I don't care who you are. Do you understand?
Yes, sir.
I'm now entering into what's called a Matchett's order for emergency protection. This is a court order that identifies Ms. Turner as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, the state can and will probably file a violation of protective order. It's one of the worst cases that you can pick up. Do you understand?
Yes, sir.
Okay, we need to talk about bond.
Your Honor, the defendant works for Enterprise. He's an IT specialist. He's been working there for over 5 years, and he's got ties here. He's been living in Houston for over 5 years, and he has child support for 3 children, that he takes care of on the weekends. They're with the baby mom on the weekdays. But he does work, and he is working, and so we would ask that, and he's no threat. He's not shown any threat previously, and he does have strong ties. So we were requesting a bond of $1,500. We have the bondsman here today who could cover that.
I would be unopposed to a bond of $1,500 if he were to have a GPS monitor with an exclusion code.
I'm
So-
gonna order it.
Yeah, so I'm unopposed to that as long as he has the exclusion code.
So, Joe.
Bond will be set at the 1,500 then. You will get no more warnings, Mr. Johnson. Don't, I mean, you're in the free world now. Act accordingly. If I find that you do anything, it's not going to go well. Do you understand? Okay, all right. So you have a bonding company here now? Okay, he'll have to meet with each all first for all the bond conditions. Then after that, we can release him to the bonding company.
He's at the check.
Yeah, for sure. Okay, all right. Thanks, Joe.